Good evening. Good evening to one and all. Good evening to all the seniors, friends, and the participants. I sincerely welcome one and all on behalf of our KJ team Legal Speak webinars. I welcome especially Mr. Bharath Srinivas, advocate, who is going to present today's webinar on the topic of determining liability under GST as a bird's view. Mr. Bharat completed his degree and enrolled as an advocate for the 3 years back. Initially, you associate with his father and Mr. others and income tax practitioners also. He is doing well. He is practicing now along with his father and in a settle excise and customs other things. Bharat Srinivas has completed his degree and started his practice only 3 years back, whereas he was especially had the passion to work with only the armed forces, other things, what is their problem, and to sort out that issue is the main ambition while starting his career as an advocate. We welcome. Also, we our team legal speak wishes him success in his career and do the best. Over to Mr. Bharat. You can start his presentation. Thank you, Mr. Bharat. You can start your presentation.
Thanks a lot, sir. The opportunity as well.
Thank you. Thank you.
Uh, Good evening to one and all, and I think it's a good opportunity for me to express the basics of my understanding in GST. So I thought going with this very basic topic of determining liability under GST, a bird's eye view, to start off my presentation, and maybe I intend to further explore these presentations into the specifics of the act. But today the focus is purely on the aspect of determining liability in the GST, and to give a step-by-step process on how it is determined under the basic concepts of the act, and for a proper understanding for a layman who has very few thoughts or ideas about how this process works. So, yeah, as far as the basics into the history, we look into Article 265 that very clearly puts across that no tax shall be levied or collected except by the authority of law. So, what I try to what I'm trying to point out in this quick look into history is the how the situation the previous law was, and a basic introduction to how it's transformed into the topic in discussion, GST. So earlier it was an activity based process, so based on different entries under union, state, and concurrent list. The state governments and the central governments, based on the powers and the entries given in their legislative field, uh, made enactments, and the basic tenets of destination-based tax applied. So they ensured that instead of, though the tax is borne by the end consumers, the ones who are doing the activities such as manufacture, sale, or service, all these aspects, they are trying to tax or levy the particular tax at the earliest point when that particular activity is commenced, and based on the rules and regulations under their different delegated legislation. So here we are trying to uh, see how different GST is. GST, once it came out, it tried to subsume all these activities by introducing a special provision in the constitution for goods and services. So um, the idea of introducing the special provision for goods and services was to just engulf all such activities and generalize the final commodity or the intermediary commodities which transcend into their development as final commodity at each stage, and target the concept of supply to be the activity that's taxable. So we look into what this scope of the term supply is all about, and how this particular first step is a crucial step going forward in the process. So here we see art section 7, that's which is very relevant and provides the general characteristics of what the term supply should denote. So here the supply, as we already know, the taxable part here is goods and services. So it must have a goods or services or both anywhere. So that has to be for consideration then in the course of furtherance of business, and it includes all forms. So earlier we saw like in the previous taxation based on entries they were doing it, but here they have confined that into goods and services, which includes all these forms: sales, transfers, barters, license, rental, lease, disposal, and all these forms. So and in particular, they have also mentioned in section 7 that it includes import of services, whether or not in the course of or furtherance of business. So these being the general characteristics of supply, we have to relate these characteristics to the question at hand. So the activity or the transaction we are conducting from business point of view should have to fall within these aspects. And what has to be done correspondingly is to make sure that we check the schedules and exemption notifications under the enactment. So there are 3 schedules. So these schedules provide for widening the either the tax base or to provide clear clarification and clarity for particular services which may or may not fall under the general characteristics of supply. So the first schedule being transactions without consideration, which are construed as deemed supply. The concept of deemed is very common under law. It basically creates a legal fiction uh, whereby even if it does not possess those general characteristics, the law uses that particular legal fiction to say that it falls within the term supply and has to be treated likewise in terms of the further processes which we'll be looking into. So schedule 2 refers to activities or transactions which are to be treated as supply of goods or supply of services. This schedule is basically gives an exhaustive list of transactions or activities which are to be treated as supply, and it's purely on a clarificatory basis. Those who clearly possess these general characteristics but require clarification and clarity. So the intent behind that is, as I said, clarificatory. And schedule 3 talks about list of activities which shall be treated neither as supply of goods nor supply of services. So um, this being very clearly put out has a very clear nexus to how negative list was there in service tax to completely exclude any kind of confusion. You have very they have clearly provided that there is the aspect of these activities or transactions don't even fall under the concept of supply. Then there's a general exemption or a special ad hoc notification issued by central government. So these are residuary powers which the central government possesses to notify either by a general exemption which applies to a particular good services or an activity or a transaction, and that will apply across uh, any person conducting such a transaction or is involved in that particular activity. But as far as special ad hoc exemption is concerned, it applies to a particular class of registered persons who are uh, conducting that activity or the particular transaction. So these are within section 11.1 and 11.2, general exemption and specific or ad hoc exemption respectively. So it has to be clearly understood in the clear box, if you can see the note, that the reference to under a particular schedule or an exemption notification or special order overrides reference to the general scope of supply under 7. So even though we have to very clearly understand that this is a general principle of this is the very clear principle of law that a specific provision would override a general provision. So The idea is to very clearly put out that the schedule entries in the schedule and general or specific exemptions will have a preference over the general meaning. So the general meaning only provides a very clear boundary, but that's clarified by the schedules and the general or specific ad hoc exemptions. So moving on, this is the second step. Once we have identified whether a transaction or a particular activity falls within the scope of supply, we intend to identify what, how the where the supply is happening. So this aspect is very crucial because it determines whether a particular supply is happening within the state or across states. So accordingly, we have to determine whether a particular transaction is liable for CGST, SGST application, or CGST, UTGST application, as the case may be, or IGST application, which means that it is applicable for interstate supply across states. And as far as that's concerned, it's intrastate supply. So place of supply is a very crucial concept here, because while determining intrastate supply or interstate supply, these are the main categorizations apart from different specific transactions or activities which are to be construed as interstate supply. What is what is an intrastate supply is very clear. If it is if the location of the supplier providing either goods or services or both, and the place of supply are the same, it would mean that it is an intrastate supply. So in case of intrastate supply, the central government and the state government have the power to levy GST. So CGST, SGST would apply, or in case of a union territory, the CGST and UTGST would apply. So interstate supply very clearly, as we saw, would apply for across state transactions where the location of supplier and the place of supplier is not in the same state or union territory. So in that particular case, IDGST would apply. IGST would apply. Integrated GST would apply. So in this particular scenario, we can clearly understand that the two key factors are location of supplier and place of supply. So this aspect of place of supply determination is crucial because it provides for what particular legislation would apply. And where the state government's powers are within, in case of intrastate supply, and how the central government has exclusive power in case of IGST. So moving on, apart from the applicability of place of IGST towards two different state transactions involving different locations for that is persons in different states. We have four other aspects, including import, supplier located in India, and the place of supplies outside India would mean export as well. And then supply to or by SEZ developer or an SEZ unit, and in taxable territory not being intrastate supply and not covered elsewhere under this section. That would be a residuary provision. So it is very clear that in case of goods, till they cross the customs frontier in India, the aspect of IGST would be applicable. And in case of services, all services are treated as interstate supply. And these are the four parts which are included in IGST apart from the general categorization which we had discussed before. So moving on, we'll be looking into this crucial aspect of place of supply determination. As location of supplier is concerned, it is a very plain and very clearly understandable where the person is providing goods from, or where the person is providing the services from, where this place of business is. So as far as place of supply is concerned, it is crucial because GST being a destination-based tax, like other forms of indirect taxation, we need to identify place of supply based on 10 to 10, 11, 12, 13 sections under IGST Act 2017. So these four sections are crucial. So moving on, in case of place of supply of goods, small table would very clearly put out the circumstances or situation in which place of supply is determined. So as far as domestic transactions are concerned, and in case where there is movement of goods involved, the termination of goods for delivery would be the place of supply. Then in case of direction, delivery on the direction of a third party, the principal place of business of the third party. Then movement of goods in a supply, location of goods at the time of receiving the same. If there's no movement of goods in a supply, then for example, if, when you're going to another state to purchase something, then the place of supply would be the place from which you're buying from. So that doesn't involve movement of goods, but movement uh, towards a particular a shop or outlet from where you're purchasing that particular commodity from. So it doesn't involve the aspect of delivery or movement of goods. So as far as installation or assembly is concerned, it's very simple: the place of assembly or installation. And then supply on board a conveyance, a location where the goods are taken on board. So where they're taking, for example, if it's delivered via a truck or a train, so where they are loading up the particular goods, they are taking that particular, in case of a conveyance, they are taking where the location of goods are taken on board. So that is the place of supply. So for each of these instances, as far as import and export are concerned, the location of importer would be the place of supply in case of import, and in case of export, it's outside India. So moving on. So yeah, as far as place of supply of services are concerned, it's they have provided a very long list, whereby the general principle would be the location of recipient in case of a registered person, and in case of unregistered person, is based on clearly the availability of records with regards to the location of the recipient. Or in other cases, they will consider the location of supplier to be the place of supply if that person is unregistered. So yeah, and like sections 12 clause 3, 12 clause 4, 5, 6, all these provide for specific instances, which I have clearly put it out in a table. So I would say you can please take this PowerPoint presentation can be mailed if necessary by our office, so that it can be referred to from a very brief point of view. But clearly, reading of the section is also essential to corroborate the same with this particular table, and also the rules applicable for each instances. So yeah, moving on. So in case of place of supply of services, where the location of supplier or the recipient is outside India. So as we saw in place of supply of goods itself, there are two categories where both the location of the supplier and the recipient are in India. But if, to clarify that it's not across different states, they have categorized that under 10 sections 11 and 12, and in 13 sorry 10 and 11 and 12, we have discussed about the place of supply of services within India, and 13 is talking about place of supply of services in this particular categorization, location where they are not in the same country. So as far as that's concerned, this very clearly similarly points out the location of recipient and the location of supplier. The location of supplier is not available as the general norm, but in specific cases, each circumstance provides for the place of supply. So yeah, as far as both are concerned, reference to the table is very clear, and the section which is word, so here the convenience is like the PowerPoint presentation clearly segregates such circumstances and situations, and accordingly the place of supply is determined. So moving on to revise the complete points, general points which we have seen under place of supply. uh, you can see these 3 points. So the aspect of location of supplier and place of supply are the two key points to determine intrastate supply or interstate supply. And the place of supply determination is very clearly denoted in these four sections under tables or based on proper categorizations. So apart from all this, IGST would include these four specific activities or transactions. So what we have to take from here is a place of supply is something that's crucial for determining the authority of levying the particular type of GST, including um, CGST, SGST, UTSG, UTGST, or IGST. That is the entire point of determining the place of supply. So the third aspect is the time of supply. As we know that it's covered. The whole point of time of supply is to determine point of taxation, which is referred to in previous legislation. So as far as the indirect tax regime under service tax or central excise is concerned, what was essentially looked at is point of taxation rules which were available back then. Here we call it the time of supply. So it derives certain principles from the previous legislations, but they have very clearly categorized the four scenarios in which you will have to determine like time of supply separately. So as far as goods are concerned, it's covered under section 12. So section 12 and section 13 covers for services. uh, yeah, section 13 covers for services. There has to be a correction there. I'm sorry about the mistake. And then section 14 covers for time of supply in case of change in the rate of tax for goods or services or both. So the four scenarios here, as we all know, is as you can see, it's forward charge mechanism, reverse charge mechanism, vouchers, and all other instances. So um, here the aspect of determining time of supply is essential, because the next steps that would follow would be determination of rate of tax, value, and as well as due dates for payment of the said tax. So uh, this clearly paves way to all the final aspects of determining the exact liability, which includes rates and everything. So moving on, uh, in case of time of supply of goods, this flowchart clearly segregates the four instances under which time of supply has different mechanisms for determination of the same. So, in case of forward charge mechanism, the earliest of the three dates, being the date of issue of invoice, or the due date for issue of invoice, or the date of receipt of payment. So, whichever comes first would be ideally the time of supply of such goods, and that would be the essence of levying GST. After that, they'll start determining value, which we'll look into. So in all the four, we need to consider that um, the aspect of due date of issue of invoice and the receipt of payment has different meanings and connotations in this context. So we need to look at circumstances in which uh, what would be the due date for issue of such invoice, or what would be the earliest uh, in case of receipt of payment. So as far as the due date for issue of invoice is concerned, if you could see the forward charge mechanism, the box for forward charge mechanism, there's highlighted in italics, there is a reference to section 31 clause 1, which clearly puts out that on or before the time of removal of goods where supply involves movement of goods. So the due date for issuing such an invoice where the supply involves movement of goods would be removal of such goods for the delivery. So that would be the instance in which the supply is supposed to have happened. Then similarly, in case of delivery of goods, on or before delivery of goods to recipient, in case where the supply does not involve any kind of movement of goods. So in case of on or before issuance or statement of accounts where there is continuous supply, and on or before time of supply subject to maximum of 6 months on the date of removal where goods are supplied on approval, sale or return basis. So if goods are given for either like a form of sample, a batch of goods are given for say not exactly testing basis, but for the recipient to know how the quality of goods are on an understanding where they can return the goods back, or based on the approval they will go forward with the transaction. In those circumstances, it's very clearly stated that there the time limit of 6 months from the date of removal is to be considered. So if it crosses 6 months, what happens is on the expiry of the last the 6th month, the time of supply would have been happened as per the provision here. And if they have removed from the factory for supply within the within those 6 months, it means that they have that particular date of removal from the factory would be um, deemed to be the time of supply in this circumstance. So as far as forward charge mechanism is concerned, those three earliest of the following, those three dates, it's very clear. And coming to the date of receipt of payment, it would be the earliest of the date of credit in the entity's bank account. That is the recipient's, that is the supplier's bank account, or the date on which the payment is recorded in the books of accounts of the recipient. So, um, as far as forward charge mechanism are concerned, the due date of issue of invoice and the receipt of payment, the meaning has to be referred to section 31 clause 1, and the meaning for receipt of payment as well in these two scenarios. So moving on, in case of reverse charge mechanism, date of receipt of it will be the earliest of the date of receipt of goods, or 30 days from the date of issue of invoice, or the receipt of payment. And the same meaning of receipt of payment which is mentioned in forward charge mechanism would apply in this scenario, but with a small difference which clearly says recording in the books of accounts by the recipient. So yeah, going forward, the reverse charge mechanism will arise in two circumstances, under 9 clause 3 or 9 clause 4. So in case of 9 clause 3, it empowers central government to it empowers the government to issue notification under which tax will be paid by recipient of goods. And this clear example would be the notification under 4 2017, notification for 2017 central tax rate dated 26 2017. So this notification clearly puts across a list of commodities which are subject to reverse charge mechanism. And as far as the notification 1 of 2019 central tax dated 29 1 2019 is concerned, it has been subjected to an amendment, because this was RCM with reference to supplies by unregistered persons. So this they very clearly provided via an amendment and notification to enforce the same, that it will not be effective till the government notifies such classes of registered persons to um, be subjected to this reverse charge mechanism. So moving on, looking into vouchers. Vouchers are basically a form of instrument where it can be exchanged in return for payment. So retention of this voucher would indicate making as an equivalent of making a payment for a supply of a good or a service. So we have already seen that in cases of forward charge mechanism and reverse charge mechanism, there is an exchange. There is a presumption that there is an exchange of amount for the supply of goods and services. But in cases of voucher, it is used as an instrument for making a payment equivalent to the supply of goods or services. So um, in these circumstances will differ because uh, the aspect which we should very clearly look at is whether a particular supply is identifiable or not at the time of issue of that particular voucher. So based on that, you have two different scenarios. So when the supply is identifiable at the issue of at the time of issue of voucher, then the date of issue of such voucher would be construed as the time of supply. So in case where the supply is not identifiable at the time of issue of voucher, then the date of redemption of voucher would be construed as the time of supply. So it is very clear that um, identifying the supply in cases of a voucher at the time of issue of voucher would be the vital factor here. So in all other instances, it's very clear under 12.5 that the due date for filing of periodic returns, or in other cases the date of payment of GST. So these two aspects shall be applicable where where the transaction doesn't fall under any of the other three categories. So um, moving on, as far as time of supply of goods is concerned, these four categories provide for different mechanisms for dealing with the same. As and in cases of services, it is it is also providing a mechanism for the exact four circumstances, namely forward charge mechanism, reverse charge mechanism, voucher, and all other instances. So here section 13 very clearly provides under forward charge mechanism the cases where the invoice has been issued on time as per section 31, earlier of the date of invoice and the date of receipt of payment. So um, there is a different meaning for the due date of issuance of invoice, or the directions under which you have to issue invoice for in cases of services under section 31. What we had earlier seen has references to goods under section 31 for issuance of invoice. So here in this particular case, we'll have to look into what section 31 provides exactly. So before we go into those two instances, I thought I'll just give you the time limit for issuance of invoice, which is like must be issued either before the provision of service or within the period of 30 days from the supply of such service. So where the supply involves continuous supply of services, the invoice must be issued on or before the due date of payment in case there's a contract, then on or before the date of actual receipt of payment, or on or before the date of completion of milestone event where the payment is linked to completion of such particular event. So uh, continuous supply has three instances. So one being a presence of a contract. Then in case where there is no contract, you'll have to go with the actual receipt of payment. Or in case of a milestone that has been agreed between parties, where when on the event, on that particular event of completing the milestone, the payment is linked towards the same, then the completion where the payment is the date of completion of the event would be the time of supply in that particular scenario. So looking into this particular aspect of uh, determining the time of supply in forward charge mechanism, we look at the two cases which we based on this clarification below. In case where the invoice has been issued on time as per section 31, earlier of the date of invoice and the date of receipt of payment. Then moving on, in cases where the invoice has not been issued on time as per section 31, earlier of the date of provision of service and the date of receipt of payment. So it is very clear that in these two scenarios, you'll have to understand that the issuance of invoice has to be within these rules, and if not within the particular time, these two instances will crop up. So the date of issue of invoice, date of provision of service, and date of receipt of payment are the three crucial aspects which has to be determined in case of forward charge mechanism to identify the time of supply. So moving on to reverse charge mechanism, the time of supply of services would be the earliest of 60 days from the date of issuance of invoice or the date of receipt of payment. So in cases where of transaction between associated enterprises where the supply of service is located outside India, the date of recording the supply in the books of accounts of the recipient or the date of receipt of payment, whichever is earlier. So uh, as far as RCM is concerned, the 60 days time limit from the date of issue of invoice or the date of receipt of payment, the earliest of the two has to be taken into account, and the associated enterprises provides for a whole new mechanism. So and then in terms of in cases of voucher, the time of supply of vouchers exchangeable for services supplied are, provided here, and if supply is identifiable at the as far as vouchers are concerned, supply being identifying supply being the crucial factor, the point of issue uh, like would be the ideal time of supply, the date of issue of such a particular voucher, or the date of retention of such particular voucher in all other cases. So if we are not able to identify that particular supply, we are going to go with the date on which the voucher is being redeemed. So that would be the time of supply. If the supply is identifiable, that when they are giving the voucher itself, we know that it's going to be exchanged for that particular service only. So that would be the date of issue of such voucher would be the time of supply. And in all other instances, it is identical to the time of supply of goods, the due date for filing periodic returns, or in other cases, the date of payment of GST. So moving on, in case this particular flowchart provides for time of supply in case of change in the rate of tax, and this is applicable for goods and services or like both. So section 14 clearly provides for two circumstances, namely when supply is made before the change in the rate of tax, that is section 14a, and when supply is made after the change in the rate of tax. So here once the rate of tax is changed, how are we supposed to understand the essence of levy? So the clarity here that has to be provided here is whether the supply has happened before the change in the rate or after the change in the rate. And what happens in case of before the change in the rate of tax is you have different scenarios in that itself. The two key factors which has to be looked into to determine time of supply is the issue and date of issuance of invoice and the date of receipt of payment. So you'll have to very clearly point out whether it is before, whether these two dates are before the change in the rate of tax or after the change in the rate of tax. So in this particular case, being when supply is made before the change in the rate of tax, and in case where the date of issue of invoice is after the change in the rate of tax and the date of receipt of payment is after the change in the rate of tax, the time of supply will be the receipt of payment or date of issue of invoice, whichever is earlier. Then, as far as the instance where before the date of issue of invoice is before the change in the rate of tax, and when the date of receipt of payment is after the change in the rate of tax, the date of issue of invoice shall be taken as time of supply. So, as far as the reverse scenario is concerned, where the date of receipt is before the change in the rate of tax and the invoice is subsequently done after the change in the rate of tax, the date of receipt of payment, which is earlier, will be taken as the particular time of supply in case of section, in case of supply, where the change, where the supply is made before the change in the rate of tax. So moving on to the next instance, it's very clearly put out in the table similarly that when supply is made after the change of the rate of tax, you it is kind of, it is a reverse scenario where uh, you'll have to look into the aspect of uh, when the supply is very clearly made after the change in the rate of tax. So whether the date of issue of invoice or the receipt of payment has, if it's before the change in the rate of tax, then the date of receipt of, similarly the date of receipt of payment or the date of issue of invoice, whichever is earlier, will be taken. And as far as the other two scenarios are concerned, is very clearly put out that when issue of invoices before the rate of change of tax, change in the rate of tax, or when receipt is after the change in the rate of tax, date of receipt of payment. And as far as the reverse scenario is concerned, the date of issue of invoice is very clearly taken as time of supply. So as far as these illustrations are concerned, the reference is provided, categorized in the PPT. So verifying that with the provisions of the Act provides you a very simple understanding of the mechanism in which time of supply is determined. So, excuse me, just so yes, as far as date of receipt of payment in the bank account is concerned, the date of credit in the bank account is, if the such credit is in the bank account, is after 4 days from the date of change in the rate of tax. So here the meaning of a receipt of payment is concerned, like you have a different meaning associated to it. So the proviso here very clearly states that if you're receiving a particular payment and the date of credit to the bank account is after 4 working days from the date of change in the rate of tax. So this particular provision will apply for section 14 aspects. So when we say date of receipt of payment here, this particular meaning should be taken into account. So moving on, this is the final step. So we have gone through the entire process of identifying what the supply is, whether it falls under the category under the scope of supply, or if it falls under any of the circumstances mentioned in the schedule or the notification. And we have determined place of supply to determine whether CGST, SGST, UTST, or IGST is applicable. And then we have come to the process of determining when the supplies also happen. Now we know that it is definitely taxable, and to what extent is taxable and what is the value that is to be taxed is the final step, after which you will have to figure out from the tariff which rate is applicable accordingly. So as far as identifying taxable value of supply, we are considering the aspect of transaction value, which is also borrowed from previous legislations. But here we'll have to read it in conjunction with chapter 4 of CGST rules, and this is also like applicable across all the forms of GST. And here the three key factors that are provided under section 15 for what transaction value is: price actually paid or payable for for supply of goods or services or both, and then supply and recipient of supply are not related, and the price is the sole consideration of supply. So these three key elements are within the are basically the definition of transaction value, and are crucial to go forth and understanding the scope of scope within which the rules and those particular provisions in different instances will apply. So as far as the price is concerned, and the price should include these particular instances, that these are compulsory inclusions to the value of supply, and there are certain exclusions to the value of supply as well. So while calculating the value of supply, the statutory inclusions and exclusions are essential to take into account. And one other crucial factor is whether a supply or recipient is related or not is something that has to be uh, definitely looked into under GST, which provides for the persons deemed to be related persons under GST. So this particular exhaustive list very clearly points out that these are the persons who are related persons, and this particular price in case of related persons and the transaction value is not applicable and not within the scope of section 15. So like moving on, this particular list clearly points out the inclusions and the exclusions, and exclusions basically are only with reference to discounts. So in case of a trade discount in trade supply or a pre-supply discount, it is very clear that discount provided post supply can be excluded at the time of valuation only in these two circumstances. Otherwise, such discounts like are not included at all. That's what is which very clearly pointed out. So if the discount is given as per the condition of pre-supply arrangement made between buyer and supplier, or in case where the ITC applicable to such discount is reversed by the buyer. So it clearly goes on to say that when ITC is applicable for a discount and when you have availed the same, there is no question of excluding that from the value of supply. So if you have reversed that ITC and if you haven't claimed any kind of a credit on that particular discount, then it's the aspect of excluding the value of supply is applicable. So that's what they're pointing out as far as a post discount post supply is concerned. But at the time of calculating um, a pre-supply discount and all is concerned, he needs to exclude discounts from the value of supply. So the taxable value will include the discount as well. So as far as compulsory inclusions are concerned, it includes any taxes, fees, sorry, any taxes, fees, or any taxes or fee charged, levied under any other law apart from GST, expenses incurred by the buyer on behalf of the supplier, interest, late fee, or penalty, any direct subsidies or subsidies provided by the government, any other incidental expenses such as commission or packaging and handling costs incurred by the supplier. So this exhaustive list provides for the compulsory inclusions to the value of supply while determining the taxable value. So moving on, these are the specific instances which the rules provide for. So what we had earlier seen in the statutory provisions under section 15, what we could understand is those three key elements and the definition of deemed related persons and the compulsory and compulsory exclusions and inclusions to the value of taxable supply are only a general a general guide, and that has to be taken into account while moving on towards each and every circumstances, which also has its separate mechanism. And as far as that's concerned, you could see that rule 27, 28 until 35, you have all these different circumstances and which have their own mechanism of dealing with the determination of value. So uh, as far as the steps of the general steps is concerned, what we have looked into today is uh, a basic framework of how the act, how the GST law is functioning towards determining liability, and how we have focused on these separate steps and how what we should be taking into account as a layman to understanding the particular concept of how the law works. So as far as getting specificity is concerned, we'll have to look into depth of the subordinate legislations as well. So, and this presentation, with this presentation, I would like to uh, uh, thank everybody who provided me the opportunity to make this presentation, and I really hope for people who have very less understanding of the GST law, this was actually an informative and as well as engaging topic. Though any tax legislations is it's a hard thing to as a subject to digest. I feel as far as GST is concerned, for the layman, this particular presentation provides a small idea as to the concepts involved in it. But if given the chance through further presentations, I would like to go into the specificity of the law. But this particular PPT provides a very general understanding of determining liability under GST. So this is, as the presentation topic calls, a bird's eye view. Uh, and I'd like to end. And in towards the end of this present, I'd like to also point out, courtesy of Mr. Seshadri sir, who is an outsourcing consultant for our office. Um, he had given, since the presentation is only with reference to um, the general concepts involved in determination of liability of GST, with all difficulty in compliance with the GST right now during these difficult times, uh, I was given this particular due date uh, screenshot involving